Sexual harassment is illegal and not tolerated in any workplace. It's estimated that 50% of women and 20% of men have experienced sexual harassment at work. Sexual harassment can inflict serious damage on an organization's productivity and morale.
And individuals named in sexual harassment complaints could lose their jobs, their reputations, and even their careers.
There are two types of sexual harassment: quid pro quo and hostile environment. Quid pro quo occurs when a manager or supervisor withholds or awards job benefits on the basis of sexual favors. This includes work assignments, hiring, termination, promotions or demotions, positive or negative performance reviews, or any other job-related benefit. Just one incidence of quid pro quo harassment is illegal and should be reported immediately. Hostile environment harassment occurs when a pattern of sexual conduct unreasonably interferes with an individual's work performance or creates an intimidating, hostile, or offensive working environment. While a single, isolated incident does not generally rise to the level of illegal harassment, severely inappropriate behavior, such as the touching of an intimate body part, can be illegal the first time it occurs. Sexual harassment does not need to be sexual in nature. A pattern of harassing conduct based on gender can also be illegal. This includes harassment based on sex, sexual orientation, gender identity, gender expression, and transgender status. Employees must be called by the pronouns of their choice and be allowed to dress and use restroom facilities consistent with their gender identity. Additionally, it's illegal to discriminate due to pregnancy, childbirth, or medical conditions related to pregnancy or childbirth. It's illegal to discriminate against a subset of a gender, for instance, treating Hispanic women different than Hispanic men. Hostile environment sexual harassment can occur between employees of the same gender identity, between employees of different gender identities, and between employees of any rank or position in an organization. Inappropriate conduct can create a hostile work environment, even if it is not directly targeted at the individual making the harassment complaint. Sexual harassment does not just happen between coworkers. The law covers harassment between employees and non-employees who work in the workplace. Non-employees include unpaid interns, independent contractors, and employees who are contracted from third-party companies to provide services in the workplace. Additionally, harassment can be perpetrated by third-party workers, like vendors, facility security workers, visitors, and even customers. Sexual harassment can happen anywhere that employees represent their organization, including work parties, dinner with clients, conferences, trade shows, sales calls, and charity events. Sexual harassment can occur during virtual meetings, telephone calls, email, text, instant messaging, or any other communication, even if the harasser, victim, or both parties are working from home. The courts use the reasonable person standard when determining if offensive conduct is illegal. In other words, would a reasonable person find the behavior severe enough to create a hostile work environment? The fact is that most sexual behaviors, when they are continuous and unwanted, meet this standard. The safe way to avoid sexual harassment is to avoid these behaviors entirely. The following behaviors are unacceptable in any workplace and could lead to illegal harassment: unwanted flirting, repeated requests for dates, and sexual propositions; sexual gestures, whistling, leering, and catcalls; long stares, and sexually suggestive looks; using crude or offensive language;
Physical assaults or threats, intimidation, or physically blocking a person's movement or ability to work;
making jokes or comments about a person's physical attributes; gossiping or spreading rumors about sexual topics, or engaging in sexual conversations that are overheard by others; unwelcome physical behaviors such as shoulder massages, hugging, and back scratching; the use of demeaning or offensive names such as honey, sweetie, hottie, baby, girl, boy, or hunk; viewing or posting sexual pictures, magazines, posters, videos, or images; sending sexually explicit texts, emails, or instant messages; viewing sexually based websites, and the use of social networking sites for sexually based messages, pictures, or videos; Making derogatory jokes or comments about a person's sexual orientation, gender identity, gender expression, or transgender status. Intentionally and repeatedly using the wrong name or pronouns to refer to a coworker. Requiring people to dress or use restroom facilities that don't correspond to their gender identity. Making inappropriate remarks or jokes about pregnancy, childbirth, or medical conditions related to pregnancy or childbirth. Offensive gender-based comments or behaviors that demean people simply because of their gender, such as, "A woman's place is in the kitchen, not the boardroom." Incidents of quid pro quo harassment and severely inappropriate actions, such as the touching of an intimate body part, threats, or intimidation, must be reported immediately. For less serious conduct, it is helpful but not required to tell coworkers that their behavior is unwanted. However, employees should report incidents of inappropriate behavior before they become severe or pervasive. Although some information must be divulged in the process of investigating complaints, confidentiality is guaranteed to the greatest extent possible. It is illegal to retaliate against employees for making or participating in a harassment complaint. Even if the complaint is found to be without merit, participants are protected if they had a good faith belief that harassment occurred. This means that managers and employers cannot punish or discipline employees for filing or participating in a harassment complaint. Likewise, non-management employees cannot bully, harass, intimidate, or threaten coworkers for participating in a harassment complaint. Both harassment and retaliation can result in disciplinary actions, including written warnings, suspension, demotion, and termination. Sexual harassment often affects future career advancement and may even hamper the ability to be hired by another organization. The loss of personal reputation and trust with coworkers, friends, and family can be devastating and life-altering. What can you do to prevent sexual harassment? It's simple. Leave sexually based behaviors at the door. Treat everyone with respect. Speak up when you witness harassment. Every employee deserves a safe, comfortable environment at work, a workplace free of harassment and fear, and full of respect. It's up to everyone to do their part in preventing harassment.
Sexual harassment is illegal and not tolerated in Illinois workplaces. Employees in Illinois are protected by both state and federal law. The Illinois Human Rights Act protects every employee in the state from sexual harassment, regardless of the size of their employer, and Title VII of the Civil Rights Act of 1964 protects workers in organizations with 15 or more employees from sexual harassment, defined as sex discrimination. Most recently, Illinois passed the Workplace Transparency Act, which requires training for every employee in the state. The state of Illinois has a long history of protecting the rights of every employee, and every employer in the state is required to have a zero-tolerance policy towards sexual harassment. This means that every complaint or known instance of sexual harassment will be taken seriously and investigated, and when warranted, perpetrators will face disciplinary action up to and including termination. There are two types of sexual harassment: quid pro quo and hostile environment. Quid pro quo occurs when a manager or supervisor withholds or awards job benefits on the basis of sexual favors. This includes work assignments, hiring, termination, promotions or demotions, positive or negative performance reviews, or any other job-related benefit. Enduring harassment as a condition of employment is another form of quid pro quo harassment. This type of harassment is often seen in office romances. Consensual sexual conduct is not illegal. However, no employee should be made to feel that engaging in a relationship is necessary to remain employed. Even if this was not the manager's intention, it's the perception of the employee that is most important to the courts. Enduring sexual harassment as a condition of employment even occurs when the manager is not the harasser. For instance, it's unlawful for a restaurant supervisor to tell employees to put up with lewd comments and inappropriate touching because it's part of the job of being a server. Just one incidence of quid pro quo harassment is illegal. Hostile environment harassment occurs when a pattern of sexual conduct has the purpose or effect of substantially interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. Sexual harassment does not need to be sexual in nature. A pattern of harassment, discrimination, or bias based on gender, gender identity, transgender status, and gender dysphoria are covered under sex discrimination, regardless of whether the harassment was sexual in nature. Additionally, employees are protected against harassment or discrimination based on pregnancy, childbirth, or medical conditions related to pregnancy or childbirth. Under Illinois law, perceived discrimination or harassment claims are illegal. This means employees are protected from unwelcome conduct based on a protected characteristic their employer perceives them to have, regardless of whether the individual actually has that characteristic. Hostile environment sexual harassment can occur between employees of the same sex, between employees of different sexes, and between employees of any rank or position in an organization. Harassing jokes, comments, or other behavior can create a hostile work environment even if they aren't directly targeted at the individual making the harassment complaint. Illinois law specifically provides protections to non-employees, such as contractors and consultants. Non-employees include unpaid interns, independent contractors, and employees who are contracted from third-party companies to provide services in the workplace. Additionally, harassment can be perpetrated by third-party employees, like vendors, facility security workers, visitors, and even customers. Illinois law specifically states that an intimidating, hostile, or offensive working environment is no longer limited to the physical location where an employee is assigned to perform his or her work. Sexual harassment can occur anywhere that employees represent their organizations, including work parties, dinner with clients, conferences, trade shows, sales calls, and charity events. The courts use the reasonable person standard when determining if offensive conduct is illegal. In other words, would a reasonable person find the behavior severe enough to substantially interfere with an individual's work performance or create an intimidating, hostile, or offensive working environment? The fact is that most sexual behaviors, when they are continuous and unwanted or particularly severe, meet this standard. The safe way to avoid sexual harassment is to avoid these behaviors entirely. The following acts are illegal, potentially illegal, or have been listed as part of successful litigation in Illinois: rape, sexual battery, molestation, or attempts to commit these assaults; threats, intimidation, or physically blocking a person's movement or ability to work; vandalism of personal or professional property, or other sabotage of an individual's work or ability to do his or her job effectively; intentional or unintentional physical conduct which is sexual in nature, such as touching, pinching, patting, grabbing, or either brushing against or poking another employee's body; requests for sexual favors accompanied by implied or overt threats concerning the victim's performance evaluation, a promotion, or other job benefits; subtle or obvious pressure to engage in unwelcome sexual activities, unwanted flirting, or repeated requests for dates; sexually oriented gestures, noises, remarks, jokes, or comments about a person's physical attributes, sexuality, or sexual experience, which are sufficiently severe or pervasive to create a hostile work environment; yelling, name-calling, and bullying; long stares and sexually suggestive looks; gossiping or spreading rumors about sexual topics, or engaging in sexual conversations that are overheard by others; displaying or posting pictures, posters, calendars, graffiti, objects, promotional material, reading materials, or other materials that are sexually demeaning or pornographic; sending sexually explicit texts, emails, or instant messages; viewing sexually based websites, and the use of social networking sites for sexually based messages, pictures, or videos; the use of demeaning or offensive names such as honey, sweetie, hottie, baby, girl, boy, or hunk; offensive gender-based comments or behaviors that demean people simply because of their gender, such as a woman's place is in the kitchen, not the boardroom; stereotyping people because they don't conform to a gender stereotype, or because they work in a job that has been traditionally held by another gender. Incidents of quid pro quo harassment and severely inappropriate actions, such as the touching of an intimate body part, threats, or intimidation, must be reported immediately. For less serious conduct, it is helpful, but not required, to let harassers know that you are offended by their conduct and want it to stop. However, employees should report incidents of inappropriate behavior as soon as they occur. All sexual harassment complaints will receive a prompt and thorough investigation, and the perpetrator or perpetrators will be told to stop immediately. When a manager or supervisor has knowledge of sexual harassment, it is considered to be the knowledge of the employer as well. Employees who continue inappropriate conduct after being told to stop are subject to increasingly serious forms of discipline, up to and including termination. If a complaint is ignored, employees are encouraged to report the harassment to another person in the organization, as outlined in the sexual harassment policy. Managers and supervisors who fail to report a complaint or knowledge of sexual harassment will be subject to disciplinary action, up to and including termination. Every employee involved in a harassment complaint must be given as much confidentiality as possible. However, warn them that in the process of an investigation, some information will be revealed to others involved with the case. Although some information must be divulged in the process of investigating complaints, confidentiality is guaranteed to the greatest extent possible. If it's determined that harassment occurred, prompt and effective corrective action must be taken. Remedies for the victim may include reinstatement, wages for unpaid time off, or restoration of sick leave and vacation time. If job benefits were lost because of the harassment, they should be awarded. For example, if a victim was passed over for a promotion due to harassment, an appropriate remedy would be receiving the promotion and back pay equivalent to what would have been earned in the new position. In many cases, employers must make changes to policies and procedures to ensure that the harassment does not reoccur. In addition to filing a complaint with their employer, employees have the right to file a complaint with the Illinois Department of Human Rights, or the U.S. EEOC, within 300 days of the harassment. A complaint must be filed with the EEOC before filing a lawsuit in federal court. Sexual harassment involving the physical touching of an intimate body part, coerced physical confinement, and/or sex acts may be a crime, and the local police department should be contacted. It's illegal to retaliate against employees for making or participating in a harassment complaint. The Illinois human rights law protects any employee who has participated in a protected activity. A protected activity occurs when an employee has filed a formal written complaint of sexual harassment, either internally with management or human resources, or with any anti-discrimination agency, testified or assisted in a proceeding involving sexual harassment, either in a court of law or before the Division of Human Rights, opposed sexual harassment by making a verbal or informal complaint to management, or by simply informing a supervisor or manager of harassment, complained that another employee has been sexually harassed, or encouraged a fellow employee to report harassment, opposed discrimination in any manner. Retaliation consists of an adverse action or actions taken against the employee by the employer. Retaliatory actions do not need to be job-related or even occur in the workplace. Unlawful retaliation can be any action, more than trivial, that would have the effect of dissuading a reasonable worker from making or supporting a charge of harassment or any other practices forbidden by the law. Retaliation can even occur after the individual is no longer employed by the organization, for instance, giving an unwarranted negative job reference for a former employee. Adverse employment actions are not automatically retaliatory. Employees are still subject to regular disciplinary rules and job requirements and must substantiate retaliation claims. If, after an investigation, complaints are found to be without merit, participants are still protected from discipline or punishment if they had a good faith belief that harassment or retaliation occurred. However, the retaliation provision is not intended to protect persons making intentionally false charges of harassment. Warn all employees involved in the case that retaliation is illegal and will not be tolerated. Both harassment and retaliation can result in disciplinary actions, including written warnings, suspension, demotion, and termination. Sexual harassment often affects future career advancement and may even hamper the ability to be hired by another organization. The loss of personal reputation and trust with coworkers, friends, and family can be devastating and life-altering. What can you do to prevent sexual harassment? It's simple. Leave sexually based behaviors at the door. Treat everyone with respect. Speak up when you witness harassment. Every employee deserves a safe, comfortable environment at work, a workplace free of harassment and fear, and full of respect. It's up to everyone to do their part in preventing harassment. Retaliation is illegal and not tolerated in any workplace. Retaliation is any action that would deter a subordinate employee, coworker, or job applicant from participating in a harassment or discrimination complaint or any other right protected by harassment or discrimination law. Some common examples of legally protected rights include filing a harassment or discrimination complaint, participating in an investigation of harassment or discrimination, being a witness in a harassment complaint or lawsuit, refusing to follow orders from a superior that would result in discrimination, rejecting sexual advances or reporting the sexual harassment of a coworker, requesting accommodations for disabilities under ADA law, requesting religious accommodations, investigating salary information to determine if wage discrimination has occurred. All other activities conducted under the belief that an EEO law was violated. Employment actions that are trivial, like minor slights and annoyances, are not considered illegal. If the action would not deter a reasonable person from asserting their EEO rights, then it is not considered illegal. Employees who have participated in a protected activity are not protected against all negative employment decisions. Employers have the right to discipline employees for reasons not related to retaliation. Full-time, part-time, seasonal, temporary, probational, future, and former workers are all protected by law from retaliation. Even if a harassment or discrimination complaint is found to be without merit, participants are protected from retaliation if they had a good faith belief that harassment or discrimination occurred. Retaliation is most often committed by managers or supervisors against subordinate employees, but it is also illegal to retaliate against coworkers. Retaliation is the most common type of complaint submitted to the EEOC. Some examples of illegal retaliation seen in court rulings and in complaints made to the EEOC include transferring an employee to another department or location, giving an unjustly negative performance review, terminating, laying off, or demoting employees, causing a loss in pay, benefits, or overtime, giving less desirable job assignments, using verbal, psychological, or physical abuse, reporting or threatening to report unrelated issues to the authorities, such as immigration status, giving a falsely negative job reference for a former employee, refusing to hire a job applicant for filing a harassment complaint against a previous employer, using unwarranted discipline. Investigate all harassment claims promptly and thoroughly. If it's determined that retaliation occurred, take immediate steps to stop the behavior and make sure it doesn't happen again. All actions after a harassment or discrimination complaint should be closely scrutinized to ensure that retaliation does not occur and that all employees are protected. Warn all employees involved in harassment or discrimination cases that retaliation is illegal and will not be tolerated. Avoid discussing the allegation in public and do not share information about the complaint with anyone who does not need to know. Make sure the complainant does not feel isolated. If the accused employee and the complainant work in the same department, separate them until the investigation is complete. However, make sure the complainant is not given an unwanted job transfer or less desirable work assignment. Apply discipline quickly and fairly. Compensate victims for any losses they incurred as a result of the retaliation, such as wages for unpaid time off or restoration of sick leave and vacation time. Retaliation has consequences. Both harassment and retaliation can result in disciplinary actions, including written warnings, suspension, demotion, and termination. Retaliation often affects future career advancement and may even hamper the ability to be hired by another organization. The loss of personal reputation and trust with coworkers, friends, and family can be devastating and life-altering. Retaliation is as illegal as harassment or discrimination itself and accounts for 45% of all charges filed by the EEOC. Every employee must be aware that retaliation is illegal and could result in disciplinary actions up to and including termination. It's up to everyone to ensure that the workplace is free from harassment, discrimination, and retaliation. All employees deserve to work in a safe, comfortable workplace, free from harassment and retaliation, and full of respect.
Harassment and discrimination of workers due to their gender identity has become a serious legal concern in today's workplace. The U.S. EEOC has defined bias against employees due to their gender identity as illegal based on sex discrimination. Additionally, 50% of state governments and numerous city and local governments also have provided legal protections. It's become imperative that all employers provide training on harassment and discrimination prevention that includes gender identity. Training for gender identity harassment helps provide companies with legal protection, but it also promotes a tolerant and more inclusive workplace that attracts a greater pool of talented employees. Gender identity discrimination occurs when a person is treated differently in the workplace or negative employment action is taken against them because of their gender expression or gender identity. The following are examples of gender identity discrimination. Requiring an employee to use a bathroom that doesn't conform to their gender identity. Refusing access to workplace bathroom facilities available to other employees. Continuing to refer to a transgender individual by the wrong pronoun in a manner that expresses hostility. Terminating employees after discovering their gender identity or hearing of a planned transition. Allowing discrimination by coworkers and supervisors. Failing to investigate harassment claims because of an employee's gender identity. Forcing an employee to wear a male or female uniform if the employee identifies as the opposite gender. Requiring an employee to wear clothing appropriate to the gender they were assigned at birth rather than their gender identity. Terminating an employee for cross-dressing away from work. Not hiring an applicant because they are transgender. Giving a lower-paying position or compensating a transgender employee less than equally qualified employees. Denying pay raises, promotions, or training opportunities to an employee because of their gender identity or gender expression. Making sexualized observations, derogatory remarks, jokes, or threats. Evaluating employees more rigidly or holding them to a higher or different work standard because of their gender expression. Reprimanding a transgender employee for something non-transgender employees do, but for which they are never disciplined. Subjecting transgender workers to sexual requests, verbal harassment, or physical assault. Create policies that allow transgender employees the right to safely use the restroom for the gender with which they identify. If possible, create gender-neutral bathrooms. Eliminate discriminatory health insurance exclusions and adopt health insurance coverage for transgender-related care. Incorporate information and education about gender identity into equal employment opportunity compliance training programs. Explain current state policies, guidelines, and proposed bills, and the likelihood of these policies becoming law if they aren't currently. Create a formal non-discrimination policy and display it on work premises and on the company website to let both current and potential employees know they are welcome. Use preferred pronouns when speaking about transgender employees. Make sure that all employee discrimination complaints are taken seriously. Although employers may be required to use legal names for official purposes, it should be clear to transgender employees that they may use their preferred name and are free to assume their gender identity. Change all personnel records, directories, business cards, and emails to reflect a transitioning employee's name and gender. Create dress codes that are gender neutral and allow transgender employees to dress in accordance with their gender presentation. Protect employee privacy by only releasing gender identity information with employee consent. The EEOC has already settled numerous cases in favor of transgender employees. Companies that fail to protect employees from gender identity discrimination could face civil lawsuits and litigation filed by the EEOC. Additionally, organizations that violate the law run the risk of damage to their reputation through media reports, social media, and word of mouth. Employees who violate the law are subject to disciplinary action up to and including termination. Every employee deserves a safe, comfortable environment at work that is free from harassment and discrimination. Companies who protect their workers from discrimination based on their gender identity and gender expression are more efficient and productive and attract a larger, more talented pool of employees. Taking steps to treat all employees fairly and equally will not only protect employers from liability, it will make their organization more productive and successful. Treating an employee poorly or unfairly due to pregnancy, childbirth, or a medical condition related to pregnancy or childbirth is illegal and not tolerated in any workplace. The legal aspects of pregnancy in the workplace are defined by several federal laws: the Pregnancy Discrimination Act, the Americans with Disabilities Act, the Family and Medical Leave Act, and the Fair Labor Standards Act. Additionally, there are many state and local laws that provide even more protections for employees. Employers must follow the state or local law if it's more advantageous to the employee. The Pregnancy Discrimination and Work Act. Businesses that employ 15 or more employees must comply with the Act. Women who are pregnant, could or intend to become pregnant, have a medical condition related to pregnancy, or have had or are considering having an abortion are all protected from discrimination in all employment decisions by the Act. This includes hiring, termination, compensation, job assignments, promotions, layoffs, vacation, training opportunities, sick leave, health insurance, or any other job-related benefit or term of employment. When women are unable to perform their jobs due to pregnancy or a medical condition related to pregnancy, their employer must treat them in the same manner as an employee with a temporary disability. If employers provide light duty, temporary reassignments, disability leave, unpaid leave, and other benefits to temporarily disabled employees, then these same accommodations must be offered to pregnant employees or employees suffering from medical conditions related to pregnancy. Some accommodations that may be used to assist pregnant employees include the permission to sit or stand during work duties, ergonomically appropriate furniture, shift changes, temporary elimination of non-essential job duties, and the ability to work from home. When an employer offers sick leave, pregnant employees must be allowed to use as many sick days for pregnancy and childbirth as are allowed for illnesses. Employers may not require pregnant employees to take time off if they're able to do their job with or without reasonable accommodation. Lastly, pregnant employees must be treated in the same manner as temporarily disabled employees when they're reinstated from leave and for how seniority credit is applied for the time during the leave. The Americans with Disabilities Act and Pregnancy. Businesses who have 15 or more employees for at least 20 weeks of the year must comply with the ADA. Pregnancy-related illnesses and conditions may fall under coverage by the Americans with Disabilities Act if, when left untreated, they would substantially limit a major life activity or major body function. Major life activities under the ADA include, but are not limited to, caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. Major bodily functions under the ADA include, but are not limited to, functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. Gestational diabetes, preeclampsia, anemia, sciatica, or depression are some of the pregnancy-related conditions that generally get accommodations under the ADA. Pregnancy harassment. It's also illegal to harass employees because of pregnancy, childbirth, or a condition related to pregnancy or childbirth. Pregnancy harassment can be perpetrated by a supervisor, coworker, or from a non-employee, such as a contractor or customer. There are two types of workplace harassment. Hostile environment harassment occurs when the behavior is so frequent or severe that it creates a hostile work environment. Generally, hostile environment harassment must be continuous and unwanted to become illegal. However, particularly severe actions such as the touching of an intimate body part, threats, or intimidation may be illegal the first time they occur. Harassment also becomes illegal when it involves an adverse employment action taken against the victim, such as termination, demotion, or involuntary transfer. Pregnancy, maternity, and parental leave. Employers may not single out pregnant employees by requiring special procedures to receive disability leave. They must be treated in exactly the same manner as temporarily disabled employees. However, if there are procedures in place to receive temporary disability leave, such as the requirement of a doctor's note, then pregnant employees can be required to follow the same rules. In addition to temporary disability leave, the Family and Medical Leave Act provides even more benefits. Under the Act, pregnant employees may be eligible for as much as 12 weeks of paid or unpaid leave for the birth and care of a newborn child. In order to be eligible for the FMLA, employees must work for an employer with 50 or more employees who work within 75 miles of their workplace. Additionally, employees must have worked for their employer for at least 12 months and for at least 1,250 hours during the 12 months prior to taking the leave. FMLA is unpaid. However, employees may use accrued vacation and sick time during the leave. Employers are allowed to require paid vacation and sick time to be used during FMLA leave. The FMLA also covers caring for a newly adopted child or newly placed foster child. Employees must be allowed to return to work with the same or a substantially similar job as long as they can perform the essential functions of the job with or without reasonable accommodation. Employers do not need to reinstate employees who applied for leave fraudulently or who would have been terminated regardless of the leave. Additionally, employers are exempted if the employee is among the highest paid 10% of the organization's staff, and reinstatement would cause grievous economic injury to the company. Break time for nursing mothers. Under the Fair Labor Standards Act, working mothers have the right to express milk in the workplace. Employers with 50 or more employees are required to provide reasonable break time and a place, other than a bathroom, for the process of expressing milk. The location must be shielded from intrusion by coworkers and the public. Employers are not required to compensate employees for the time spent expressing milk, but employees may use paid breaks for this purpose without penalty. Retaliation. Employers cannot retaliate against employees for participating in their legal rights under the Pregnancy Discrimination Act, the FLSA, the ADA, or the FMLA. This includes filing, participating, or being a witness in a harassment or discrimination complaint. Retaliation is just as illegal as harassment or discrimination itself and is the #1 complaint filed with the EEOC each year. In conclusion, harassment or discrimination of pregnant employees by supervisors, coworkers, customers, contractors, or anyone else is illegal and not tolerated in the workplace. Employees who violate the law are subject to disciplinary actions up to and including termination. All workers deserve a safe, comfortable environment at work. It's up to every employee to follow the law and to treat pregnant employees with dignity and respect. The world is changing. New technologies allow more people to work from home and less people to travel for business. Most business communication is now electronic. Electronic communication has made the workplace far more productive and efficient. However, the convenience of electronic communication has resulted in far greater legal risk for organizations and their employees. A single piece of electronic communication can travel to multiple offices and be seen by thousands of people, exponentially increasing the legal exposure for organizations. It's critical that every employee understands that their electronic behavior is subject to the same laws and organizational policies as their behavior in the office and in face-to-face communication. Offensive behavior is always unacceptable, regardless of the delivery method. If a remark is offensive in person, it's offensive when delivered electronically. Electronic harassment is the use of computers, cell phones, or other electronic devices to threaten, embarrass, intimidate, harass, or humiliate coworkers or other persons in the workplace. When electronic harassment is used to target members of a protected group and creates a hostile work environment, it can become illegal. Hostile environment harassment occurs when a pattern of offensive conduct unreasonably interferes with an individual's work performance or creates an intimidating, hostile, or offensive working environment. The federal government protects employees from harassment and discrimination based on race, color, national origin, religion, disability, family status, including marital status and pregnancy, sex, including sexual orientation, gender identity, and transgender status, age, 40 and over, and genetic information. In addition, local laws and organizational policies prohibit the harassment of many other groups of employees. The courts use the reasonable person standard when determining if offensive conduct is illegal. In other words, would a reasonable person find the behavior severe enough to create a hostile work environment? The law only looks at the perception of the victim. The perpetrator's intent is irrelevant in court. Quid pro quo harassment occurs when a manager or supervisor withholds or awards job benefits on the basis of sexual favors. Quid pro quo harassment can also occur electronically. For instance, a manager cannot withhold or award job benefits in an effort to force employees to send inappropriate pictures or engage in sexting. Additionally, employees may not be made to endure harassment as a condition of employment. For instance, a manager cannot tell salespeople that they will have to put up with degrading jokes and pictures sent to them electronically because this behavior is commonplace in sales departments. Just one incidence of quid pro quo harassment is illegal. It's also illegal to harass coworkers because they're perceived to be members of a protected group, even if they aren't actually members of that group. For instance, it's illegal to harass a coworker for being Jewish even if she isn't actually Jewish. Additionally, it's illegal to harass employees because of their association with members of a protected group. For instance, it's illegal to harass an employee because of his wife's nationality. Electronic harassment can occur between peers or between a manager and a subordinate employee. The law covers harassment between employees and non-employees, such as unpaid interns or independent contractors. Additionally, harassment can be perpetrated by third parties like vendors and customers. Harassment can occur anywhere that employees represent their organizations. This could be in a hotel room, at a trade show, on a sales call, or even at home from a personal device. The following are examples of electronic harassment that may create a hostile work environment and therefore leave employers potentially liable. Sending harassing messages via social media platforms such as Twitter, Facebook, and Instagram. Posting pictures, videos, or messages that depict coworkers negatively. Cyberstalking by obsessively following a coworker on their social media networks and blogs. Sending harassing, intimidating, sexually explicit, or inappropriate text messages or photos by text, email, or instant messaging. Sharing secrets about victims with other employees, such as their search for another job or their sexuality. Damaging a coworker's computer by sending viruses by email. Encouraging others to harass a victim by falsely claiming the person has harmed them or their family. Threatening to release harmful information about victims to blackmail them. Impersonating coworkers, business associates, managers, or company executives to post or send inflammatory comments. Posing as the target to express interest in sex on dating sites, social media, or through electronic communications. Harassing a coworker during a live chat, conference call, or video meeting. Sending or posting hateful speech that attacks a specific aspect of the target's identity, such as race, ethnicity, religion, or gender identity. Message bombing or intentionally flooding phone or email accounts to limit or block access to a coworker's devices. Sending or posting private sexually explicit images or videos of coworkers or business associates. Damaging a coworker's reputation by posting false information online, such as fictitious criminal records or lies about sexually transmitted diseases. Use strong random passwords and log out of all accounts when not in use. Keep all devices secured, password protected, and locked when not in use. This applies whether working in the office, off-site, or at home. Think carefully before posting on social media. Only comments, photos, or messages that do not violate company policies are acceptable. Even posts on personal accounts from personal devices could be seen by coworkers or business associates. Make sure that all communication sent via text, email, or instant messaging does not violate company policy or break local, state, or federal laws. Promptly notify managers or supervisors about inappropriate behavior by following organizational reporting procedures. It is illegal to retaliate against someone for making or participating in a harassment complaint. This means that managers and employers cannot punish or discipline employees for filing or participating in a harassment complaint. Likewise, non-management employees cannot bully, harass, intimidate, or threaten coworkers for participating in a harassment complaint. Even if the complaint is found to be without merit, the participants are protected if they had a good faith belief that harassment occurred. Electronic harassment and retaliation can result in disciplinary actions including written warnings, suspension, demotion, and termination. Electronic harassment can result in fines and judgments from the EEOC and millions of dollars in civil judgments. Some types of electronic harassment may violate criminal laws such as pornography or cyberstalking. Employees who violate the law could face restraining orders and even prison time. Electronic harassment causes decreased productivity, employee turnover, absences, and elevated medical costs due to added stress at work. Harassment charges often affect future career advancement and may even hamper the ability to be hired by another organization. The loss of personal reputation and trust with coworkers, friends, and family can be devastating and life-altering. Electronic harassment is a serious concern for employers. It's essential for companies to protect their employees and avoid costly and embarrassing litigation by taking proactive steps to prevent such abuse. All employees deserve a safe, comfortable environment at work, a workplace free of harassment and fear and full of respect. It's up to everyone to do their part in preventing harassment. Everyone in the workplace should understand the available options for filing a complaint. How sexual harassment allegations are reported is a personal decision. These 4 options are not mutually exclusive. Witnesses or victims may select one or more of these options. Report the harassment to the victim's employer. File a complaint with the Chicago Commission on Human Relations, CCHR. File a charge with the Illinois Department of Human Rights, IDHR. File a charge with the U.S. Equal Employment Opportunity Commission, EEOC. Report the incident to one or more of the following persons in the workplace: a supervisor or a trusted manager. Supervisors and members of management are responsible for understanding the organization's internal complaint investigation and resolution processes. Managers and supervisors can get immediate relief for victims. Human resources officers may be the best option when the harasser is a manager or supervisor. They can work with management to investigate and resolve sexual harassment complaints. Sexual harassment reporting officers are often established by employers to specifically receive and investigate sexual harassment complaints. This is the best option if it's available. The CCHR is the civil rights agency for the City of Chicago responsible for enforcing the Chicago Human Rights Ordinance, which makes it illegal to engage in sexual harassment or retaliation. Provisions of the agency include: victims may file a charge at any time within 365 days of the incident or incidents. The harassment must have occurred in Chicago. Complaints may be filed with CCHR in person, online, by email, or by fax. CCHR has the authority to investigate employers who have one or more employees. Remedies available under the Chicago Human Rights Ordinance. After an investigation by the CCHR, if substantial evidence of an ordinance violation is found, a public administrative hearing will be held before a hearing officer. The hearing officer will make a recommended decision on liability and relief. The CCHR Board of Commissioners may either accept, reject, or modify the decision of liability and the recommended relief. The decision may include a fine from $5,000 to $10,000 per violation paid to the city. Remedies for the complainant may include damages, out-of-pocket, emotional distress, punitive damages, injunctive relief, order to correct discriminatory practices, and attorney fees and penalties under other ordinances. The Illinois Department of Human Rights, IDHR, is a state agency responsible for enforcing the Illinois Human Rights Act. This state law makes it illegal to engage in sexual harassment or retaliation. Provisions of the agency include: victims of sexual harassment may file a charge at any time within 300 days of the incident or incidents with the IDHR. IDHR has the authority to investigate employers with one or more employees. To start the process, victims should submit a complainant information sheet to IDHR. Remedies available under the Illinois Human Rights Act. After IDHR completes its investigation, the victim, 1, may file a lawsuit in civil court, or 2, may file a complaint with the Illinois Human Rights Commission, IHRC, if IDHR found substantial evidence of a violation. Complainants who prevail with the IHRC or in court may receive an order awarding remedies allowed by the Illinois Human Rights Act to make the complainant whole. Remedies may include back pay, lost benefits, clearing of a personnel file, damages, hiring, promotion, reinstatement, front pay where reinstatement is not possible, and attorney's fees and costs. The United States Equal Employment Opportunity Commission, EEOC, is responsible for enforcing Title VII of the Civil Rights Act of 1964. This federal law makes it illegal to engage in sexual harassment or retaliation. Provisions of the EEOC include: victims of sexual harassment may file a charge at any time within 300 days of the incident or incidents. The EEOC has the authority to investigate employers who have 15 or more employees. To start the process, call the EEOC or visit their website. Remedies available from the U.S. Equal Employment Opportunity Commission. After the EEOC completes its investigation, the complainant, the employee, may file a lawsuit in federal court. The EEOC may help parties reach a settlement through an informal process called conciliation if the EEOC finds reasonable cause to believe discrimination occurred. Complainants who prevail in federal court may receive an order awarding remedies allowed by Title VII to make the employee whole. Remedies may include back pay, lost benefits, clearing of a personnel file, damages, hiring, promotion, reinstatement, front pay where reinstatement is not possible, punitive damages, and attorney's fees and costs. Witnesses in Chicago have a duty to cooperate in sexual harassment investigations. They must be truthful and disclose all known information about the case to internal or external investigators when requested. Employees who fail to cooperate, are not truthful, or don't disclose all known information are subject to disciplinary action. The CCHR is the civil rights agency for the City of Chicago responsible for enforcing the Chicago Human Rights Ordinance, which makes it illegal to engage in sexual harassment or retaliation. Sexual harassment complaints may be filed with employers, the Chicago Commission on Human Relations, the Illinois Department of Human Rights, or the U.S. Equal Employment Opportunity Commission. Remedies for sexual harassment may include back pay, lost benefits, clearing of a personnel file, damages, hiring, promotion, reinstatement, front pay where reinstatement is not possible, and attorney's fees and costs. Witnesses in Chicago have a duty to cooperate in sexual harassment investigations, and employees who fail to cooperate are subject to disciplinary action.